Well, I really like that. Restorative versus adversarial, which means you're changing the core concept of dispute resolution, the ideology behind it. Because today the adversarial system is, well, it's actually breaking, isn't it?
Yeah. So the adversarial system is under immense pressure. And I like the way you put it, that yes, India has now started to ask that galti kiski hai ki jagah, how we can do it better, how we can make it better. So we do understand that the judiciary is under immense burden. There is a huge backlog of cases. And it's, if I put it in a very simpler word, let's just take an example of a businessman, a small shop owner. He has a case where he has to claim 2 lakh rupees of money. If he's paying 20,000-30,000 to the advocate, court fees, and he has to wait 5-6 years to get that money back, he has already lost. Justice to mila hi nahi.
Right.
That is why I resonated with the very recent fact that Honorable Chief Justice Suryakant said that justice delayed is not justice denied, but it's justice destroyed. I did ponder upon that fact for a very long time because it takes you back to the Niti Aayog report where they have a 3-4 problem. Now that problem is that considering the current backlog that we have in cases, and the kind of process we have for now, it would take 324 years to clear that log jam. And it's just not acceptable.
Right.
At the same time, we understand that increasing the number of judges, increasing the digital or maybe infrastructure of any kind would be very helpful. But I am very sure that we do not need faster horses. We need a new vehicle in itself. Also, talking about even if we go outside of Niti Aayog, outside of our country, we come across reports like Ease of Business Doing report, where again, contract enforcement is a major issue.
Sure.
We come across the Justice Gap report, where it is very evident that 90% of the people don't even file cases. They have such social stigma against the court kacheri behavior that they would not want to go and actually get justice. They would want to stay at their home. They would not want to take part, which is again not something envisioned in our constitution.
Right.
So it is a burden, of course, but yes, so I believe that ODR would be the biggest solution to this problem.
And I think the judiciary knows this because, which is why we're seeing a lot of e-courts, digital lok adalats, and also mediation centers.
Correct, right. So the judiciary, the government is all working on ADR and mediation. So it is for sure something that we have to look upon. It is also a signal to us that we, or I consider the ODR institutions to be a partner of the court to declog all this system, to make sure that the burden of judiciary is lessened. And how that could happen would be maybe judiciary or the courts taking up very constitutional framework matters of very serious concerns, maybe criminal matters too. But any matter that relates to a commercial dispute, very small collection dispute, that should not clog a judge's desk. It should be moved towards ODR, having the same nature. It can be easily resolved there within a stipulated time. That's why we see that courts are themselves pushing for mediation in commercial matters. The courts want mediation in family matters. The court want arbitration in various kind of different cross-boundary matters, cross-territory matters. So I do believe that yes, the judiciary and the government is on our side, and they have become the wind at our back so that we can progress more and more into the ODR domain. Also, to add to this, government is also introducing the arbitration amendment bill. And in the bill itself, you can clearly see their vision that they want more and more ODR players in the market.